Once we get everybody in here, then we'll go into what we're going to go into here, because this is going to be rather important. And Helen, this goes directly to your case and directly to the complaint in your case regarding the headlamps. Okay? Now, can someone tell me what the importance of the contents of a criminal complaint are? Not what's important about just the complaint itself, but what is there that is important to understand about what it contains. And
the elements?
It's not a trick question.
What Florida statute, criminal code you're being charged with?
And it's not a easy question to answer unless you've been at this for a long time, because there's several ways you could answer this and they would all be correct. But I doubt you would find one that's directly on point with what I'm trying to ask you, because you may or may not have realized this point of it, but I'm just testing to see if anybody might. Now, here's what we do know for sure. That a criminal complaint, when it makes an allegation of a criminal violation, it must allege all of the elements of the act that are required to be asserted and proven at trial. Okay? That's a given. It cannot miss any of the required elements. Okay? They must all be there or the charge is invalid. They must all be stated. That's what must be in the complaint. And they must all be proven. Meaning, if it's in the complaint, they must offer proof of it at trial in order to convict. They cannot offer a complaint with 15 elements and only get evidence of 12 or 14 of those 15 in at trial and say they won. If it's in the complaint, they have to prove it. Everybody understand that concept?
Yes.
Yes, sir.
If it's in the complaint, it has been alleged and asserted. Therefore, it must be proven. And guess what? At that point, it doesn't matter if it's an actual element of the offense or not.
Why?
Because it's a fact alleged in the complaint, and they must prove it to be true. Period. Okay? And there is case law out the yin-yang on that. Everything required to be alleged must be proven. So, now, the problem we have in Helen's case is that, number one, there is no such offense. Okay?
Exactly.
That's problem number one. Problem number two, since there is no such alleged offense, there is no clear delineation of what elements must be asserted and proven in order to convict. Proof of that is how the prosecution wrote this complaint in her case, dealing with the headlamp charge. Okay? And let me show you what I mean by that. This is the complaint against Helen relating to the headlamp charge. Okay? Can everybody see it?
Yes, sir.
Now, more importantly, can everybody read it?
Yes, sir.
Okay. So let's see exactly what it says in this section right here. Okay? Now, it's also important to note that form-wise, every complaint is required to have this and this. If it doesn't have either of those, it's an invalid complaint right off the bat. It's bad on form. Okay? Now, back to this. On or about January 28th, 2024, did then and there, and this is a reference back up here, does believe that Helen Kathleen Reyes, hereinafter called defendant, did the following. Did then and there unlawfully drive and operate a motor vehicle upon a public roadway in this state, to wit, Magnolia Avenue, at its intersection with 12th Street, wherein situated.
I was, well, And this particular Magnolia Avenue is right past the Knoll Street exit.
No, it's city of Port Neches in the state of Texas.
Right.
Okay? But there's no county.
No, it's Jefferson County, Texas. That should be there.
But it's not there.
Nah.
Okay. Second thing is, during a time at least 1/2 hour after sunset and at least 1/2 hour before sunrise, or when light was insufficient or atmospheric conditions were unfavorable so that a person or vehicle on the street was not clearly discernible at 1,000 feet away. Here's the problem. It can't be one or the other. They have to pick which one they're saying you did wrong. So it either has to be a half hour before or after sunset, a half hour before sunset, or sometime in between, or when light was insufficient or atmospheric conditions were unfavorable.
This happened at 12:30 a.m.
Which isn't listed in the complaint at all.
Nope.
The exact time is not there. So, since there is no exact time, how do we know it was between this time and this time?
I see where you're going. Chip away. Chip away.
Okay? There's nothing in the complaint that says when the act allegedly occurred. They're just giving a broad range of time. And the requirement is that they must specify to the greatest degree possible.
I see what you're doing. You sharpen the axe, and now you start chipping away at their complaint by each item that they've stated in the complaint.
Okay, now, and then it actually says without having at the front of said motor vehicle at least 2 headlamps, 2 lighted headlamps. Well, the problem is they can't show where the statute says that. They cannot show anywhere that the statute says they must have at least 2 lighted headlamps on the front of the vehicle.
It's not in there.
At any time of the day or night.
It's not in there.
But here is their biggest problem, in addition to the fact that there's no such offense. When did the officer measure the lights on the front of your
Let me
car?
tell you what he said, because I got him to admit it on the stand. And did you measure? No. During your observations? No.
Okay, wait, stop. I'm not talking about the distance at which he saw you.
No. On my lamps. During your observation, during your inspection, did you see? And he said no. He didn't. He didn't check to see if any of the other lamps were functioning. He didn't check to see whether or not they were placed on there correctly.
Okay.
No.
Not exactly my point. Let's focus only on the headlamp portion of this, where they specifically say that each headlamp, stop talking, let me finish, that each headlamp must be on each side of the front of said motor vehicle mounted at a height of 24 to 54 inches. Who did the measuring for that? When did they do it? What evidence are they going to introduce at trial that this is a true statement if no one did it?
Exactly. And basically that throws their...
And see, here's the other proof that there is no specific charge. They had to call together 3 separate statutes to make the allegation. 3 separate statutes. And none of them say this.
Let me ask you something, Eddie.
Yes?
After I did a little bit of research from the Texas Municipal Education Center's forms, isn't this form in there?
The complaint form?
And they just copy and paste This for
Well,
like,
the form, it doesn't necessarily have the language. It's just a template form. Okay? They're still responsible for putting in the actual language of the charge. Now, there may be templates for the most common ones they do, and some attorney in some municipal office may think they know more than everybody else, and so they just go ahead and write their own. But this right here is a perfect example of what happens when they write their own.
oh yeah, it's completely crapped up.
Okay? Now, the question here is who did write it? Was it one of these two court clerks? Or was it the city attorney?
I'm wondering if it was the city attorney.
Well, it doesn't matter because it proves one of two things. Either they have unlicensed individuals filling out complaints to charge the public, which are the court clerks, or they have a licensed individual who's fucking incompetent at their job, that is living off the public dole.
And I can tell you this. Before I went to pretrial this time, I went to announcement docket, and that city attorney that's acting as a prosecutor in that municipal court was defending another person inside the same court of county law, court at law number 2, Jefferson County, where I was that same day, because he was coming up the stairs and I recognized him. I said, oh, that's the asshole that I had to deal with.
And that would mean he's from a private law firm.
Yes, he is.
He's contracted to act as a city attorney.
Yes, he is.
Then where's his oath of office and his anti-bribery statement?
And I bet he don't have either.
I'll bet you're absolutely right.
Related to that, Eddie, out of curiosity, in Texas code, I've seen some things in Arkansas code is related to the prosecutors, and they're not allowed to practice as attorneys otherwise during their term as
if they're elected.
If they're elected, okay.
Okay, city attorneys are not elected; they're appointed. They're private counsel for a public corporation, the municipality. They're different than an elected prosecutor.
Roger that. Thank you.
Yep.
Now, this prosecutor has his own practice here in my town, which is 2 minutes away from Port Neches. We're rival towns. We have the biggest.
But he is acting as a city attorney, correct?
Yes, he is.
Okay, now, you need to file a public information or public records request or public information act request and get a copy of his oath of office and anti-bribery statement from the city secretary.
From Port Neches, correct?
Correct.
Okay.
Hang on just a second. Let me verify something, but I'm pretty sure that is going to be the custodian. Since he's a municipal employee, the municipal secretary is the custodian of record for them. All right. Chapter 602 of the Government Code, 602.002, Oath, made in Texas. An oath in this state may be administered and a certificate of the fact given by these people. And let's see if it tells us who has to take it. All right, all other officers, straight out of Article 2 of the Article 16 of the Texas Constitution, Article 16, Section 1, all other officers shall retain the signed statement required by subsection B of this section with the official records of the office. Well, he's municipal attorney, therefore it is the city secretary. And or possibly the city manager. So that's who you go to get a copy of his oath of office and anti-bribery statement.
Okay, so city secretary or city manager, correct?
Correct. What I'd do is I'd file one with the mayor, the city manager, and the city secretary and see if they all wind up in the same place.
So I just need to do a public information request?
Yep. Just make sure you name the attorney specifically that you're wanting the oath of office and anti-bribery statement for.
Okay.
Because if they've been acting as legal counsel for the municipality without those for however long, then they've been committing fraud by impersonating a public official. And the city is on the hook for letting them do it. That's going to be a real shitstorm.
And Eddie loves to have shitstorms.
As long as you ain't the one on the receiving end of them, you're damn right I do.
Yes, we want to create it, right?
Yes, we do.
Eddie, can you comment on when you make a government information request and they charge you like, or they put on tax? I made an information act and they charged me $85 for IT help and then another $50 for.
Again, here in Texas, I can't answer for every other state, but here in Texas, there is a specific part of the law that says what they can charge for what. And they cannot charge any more than the law authorizes them to charge. Period. I'm pretty sure your state's going to have the same thing. You just have to find it.
All right.
So look for whatever your Public Information Act is, or your FOIA Act, or whatever it is in your given state. Just go on Google and do a search. What are the public information accessibility laws in my state of, and whatever the name of your state is? Okay, try something like that. Word it different ways till you find what you want.
I want to recall here. Now you've got some forms to make public information requests. Is that correct?
But the ones I have are specific to the DPS and the police agencies, relating to an officer's certification to enforce the transportation code. They'll give you a good idea of how to write one, but they are specifically designed for that purpose.
So in my request, my written request, do I need to use their forms to ask for this?
No, you can hand write a request. You can do it via email if you want to, but I recommend that you be as focused and specific as possible. Okay, don't be general and vague and overbroad with it. Keep it focused on exactly what you want. Okay, the person who works for the place who does the thing.
So am I, to whom it concerns, I am making a public...
No. To the custodian of records for the municipality of Port Neches, Texas. Okay?
Okay.
That's who you direct it to. Custodian of public records for the city of Port Neches, Texas.
Okay.
I hereby seek the records for the following individual who is currently operating as the municipal attorney for the city of Port Neches. Then you give the person's name, and then you ask for employment history. Okay. Salary or contract, or a copy of the contract with the firm he works with. Oath of office. Anti-bribery statement. All right, and get certified copies of those.
Okay.
And the reason you need certified copies is they're not admissible without a witness unless they bear an official seal. If they bear an official seal, they're self-authenticating.
So then I need to make the demand I would like, or I am requesting certified copies.
Yes.
City manager, city secretary.
Please provide the records of fulfilling the above request as certified records. And they'll probably charge you, I think, $16 for that.
Okay.
On that note, Eddie, I actually just got my envelope back today from the Arkansas Supreme Court clerk that includes all the oaths of offices for each of the county judges and for each of the county prosecutors. And they're supposed to be sending me their state attorneys' licenses as well. They weren't in this envelope, so I'm taking it they're probably coming separate.
Okay.
strange or a twist on Arkansas is in their Freedom of Information Act, as it's written, they require you to be a citizen of the state to be able to get the information. And some of them are giving me the info anyway. Some of them are refusing to give me info related to it. Like I ran into with the RDOT, Arkansas Department of Transportation, and getting traffic studies that are listed as requirements for certain speed limits.
I'm pretty sure that could be challenged as unconstitutional. Public information is public information, and that means the entire public, not just those within the state.
Right, and
that's exactly why people who don't live in a particular municipality can still attend and speak at public hearings and public meetings. They don't have to live there to speak and give an opinion. There's no way in hell they can turn around and say, but we can limit what records you can access if you don't live here, even though they're just as public as the meeting is.
Right.
But does everybody understand what I'm getting at about this complaint? The complaint asserts several things that they are not going to be able to offer any evidence in support of.
But we all know that they're going to try their damnedest to do so.
Here's what we do know. You need to figure out how you're going to ask the questions to trap them into proving they can't prove what's in this complaint.
Yeah.
So step up and let's go.
That's right. I'm stepping it.
Right now, step up and tell and question me to prove why this can't be proven. Put on your thinking cap and let's see you ask the questions that are going to trap me into not being able to prove what's in this complaint.
All right, well.
Now, is the date correct?
Yes.
Okay.
The date is correct.
Now, what is important here is that you do not ask questions about things that are not in the complaint so that they can offer testimony to it, especially if it's a missing element. Mm-hmm. Okay? Mm-hmm. So the question here is, which specific section of this are they trying to say you violated? Because they're trying to say it's one charge. How are they going to do that with three separate statutes?
Yeah.
No. They're using language from three separate statutes to fabricate a charge that doesn't fucking exist.
Right.
Okay?
Correct.
So how do you trap them into admitting that there is no such charge and that they cannot prove what they've got here? That's your task. Come on, you should be able to think on your feet. Each one of these pieces of each word up here. Do you ask them what time this allegedly occurred?
Yes.
Why? Is it in the complaint?
No.
Then why would you ask them to put testimony on the record to prove the element that's missing? If the prosecution fails to do it, why on earth would you do it?
Yeah, because the prosecution asked him last week what time, and he said about 1:30 in the morning. It was 12:30 in the morning, actually. But
and
yeah,
did you object and say there's no such statement in the complaint?
No.
Okay. That would have forced them to amend the complaint. But now guess what?
Uh-huh.
Are you listening?
Yeah, I'm listening very closely.
Okay. Now they have an actual hearing where the officer gave testimony that stated an element that is conspicuously missing from the allegation. Now you can file a motion to challenge the complaint as being legally insufficient on its face for not stating all the required elements of the alleged offense. And here's the testimony from this date on this time by this officer showing that information is not stated in the complaint.
Okay. Now here's the thing. We have pretrial conference hearing on March 2nd. Do I do it before then or after?
File it in writing as soon as you can, challenging the sufficiency of the complaint, but you need the transcript from the last court session.
Okay. So this last court session that just occurred.
Yeah, the one where the officer got up there and gave that testimony, that's the one you need.
Okay. And usually how long does it take? About a couple of days?
I can't answer that. That's going to be up to the court reporter.
Which I found interesting because the court reporter that was there was a young guy and he had a mouthpiece. So I don't know if
he was speaking into it and it was recording everything, and then he'll go back and transcribe it later. I don't know why the fuck they do that.
Okay. I wasn't sure because usually it's I thought it would be the stenographer, but this was a little different. But it's okay. I mean, I can go ask the clerk's office, right? The county clerk. Yeah.
You have to get them to put you in touch with the court reporter or ask them where can you get a copy of the transcript from that court session.
Okay. I'll just go down there in person and ask.
Okay.
And then we can review it, right, in class and determine what we need to put in the complaint or our motion. Yeah, absolutely. I'll go do it. Hell yeah.
Okay.
Anything
now, that's likely not going to be cheap.
No, it's not. Yeah.
Now, let me ask you this.
Uh-huh.
I can't tell you how much it is. It will change from court reporter to court reporter depending upon whether they are independent and work on contracts by the page or whatever. They ain't no telling what the fuck they'll charge for it.
Okay. But we could also run into issues with the judge also altering it, correct?
Well, it's possible depending upon who the court reporter works for and whether or not the judge ordered them to do it before or during the setting or after.
Okay.
The judge can order stuff stricken from the record, but he has to do it in open court. He can't come back after the fact and behind everybody's back do something that alters the record in the favor of one party.
And he never asked for anything to be stricken, believe it or not. So.
Okay. Well, in any case, we need that transcript so we can point out that the officer testified to this date and this time, which is allegedly a required element of the offense, and it's not stated in the complaint. Therefore, the complaint is legally insufficient on its face and must be quashed or set aside. That's your goal with what you're going to get.
Absolutely.
All right. But regardless, for right now, while we're waiting on that, let's see what you can come up with to argue why they can't prove their case. Let's pretend that you're now at trial, not trying to get the complaint dismissed, but now you're trying to defend against the allegations in the complaint, and you need to ask questions that will prove that they can't prove any of what they're asserting here.
Yeah, I'd have a hard time doing that on my feet.
Well, that's the problem, folks.
Right.
That right there is the problem.
Hey, I'm honest. I
understand you're honest, and I'm not knocking you for being honest.
No.
But what I'm telling you is, this is why you must study this till you can argue it backwards, forwards, upside down, sideways, vertically, diagonally, horizontally, doesn't matter. Fourth dimensionally.
Now, one thing I do have that I kind of studied through, but it's not exactly, but it could be tweaked as, is you have a, I think it's one for transportation. It was a cross-examination script. Is that something that I should still use to kind of tweak through and see how I can create the questions based on how that's set up?
You can, yes. But here's the thing, guys. Everything has a logical sequence. Okay?
Right.
This is why if you understand what the elements are, then you understand what the sequence is. Now, they can argue each element out of order. That part doesn't matter. But they must testify to some fact or evidence that supports that element at some point. So the order of presentation of the elements isn't relevant. What is relevant is, did they name them all? Did they prove them all? And do they have the evidence to back it up? Okay? That's what you're focused on. So this is what they've got in the complaint, but we know for a fact that certain things are missing that would be required to be here, and they don't have it.
Do you have the copy of his affidavit that he made?
That who made?
The cop.
I don't know.
I think I
What
gave
file
you
is
a
it
copy
in?
of it. It might be in the public file.
I don't know
I'm
what
going to
you
look
mean
in
by
here because I have it
public
in my trial. I have it in my little trial notebook. Hold on. I'll get it.
So, Eddie, what would be a good way of keeping track of that when you're in trial? Just have a checklist, check them off. They miss one, hammer them on it.
Well, what you should have done was made an outline of the charge, the elements for the charge before you started. You need to know everything they're required to assert and prove. Okay? And if they miss one, then they're done. But if you don't know what they are, you're not going to know if they missed one. You're not going to know if what they said or presented is sufficient to prove it either. Okay, like for instance, the complaint says that these two lighted headlamps are not mounted at a height of 24 to 54 inches as required by one of these three statutes. But they have no evidence to support that. Not to mention, that would not be an element of operation. That would be an element of lack of equipment.
All right. Let's see if you have his Class C offense report, which is, let's see, this is his probable cause. Affiant has probable cause for said belief because of the following facts. On
I don't have that.
Okay, I'll read it to you.
Wait a minute. Is this Bradshaw? Is that the cop's name?
No, his name is Hellman, Heilman. Officer Eric Heilman, whatever.
Okay. Let's see if it's in.
It might be at the end of the call report.
Okay. Hellman Eric incident number. Is that what you're reading? Says Hellman Eric on Sunday 1/28/24.
Yeah, that's at approximately 109 hours. Yeah.
Okay.
That's where he's put all of his facts, which would have been in the complaint, right?
Well, let's
But
see.
here's his facts. You can read through them.
All right. Well, this says Magnolia and 12th Street.
Mm-hmm.
And yet his statement says Magnolia and Knoll.
Right. 12th Street is where he pulled me over, but at Knoll is where he was sitting in the left-hand turn lane with his cruiser lights off, and he was just sitting. But when you look at the video, and this is why we need the video, okay, it has him pulling me over about, I want to say, a fourth mile away from where he testified that he stopped me and saw me. And it had his cruiser lights working. It's crazy.
Okay. I continued to speak with the female and told her numerous times that she was required to have and required to present to me a valid driver's license while operating a motor vehicle along a public roadway. The female continued to be uncooperative and began making various demands of me. The female began demanding she be provided with a lawyer and requested a supervisor respond to the scene. After giving the female numerous opportunities to comply with my orders, I advised her she would be given one more chance to either provide me with a driver's license or tell me her name, or she would be placed under arrest. Except he didn't give you a chance to either provide you with the license or tell you your name, because you'd already told him your name, right?
I don't recall. I really don't.
Okay.
I'd have told him, if I'm not mistaken, it might have been after the fact when I was placed under arrest. But like I said, I don't exactly recall.
Okay. I was very clear with my request, told what she was required to do, and stated what my course of action would be based off her responses. Also, by this time in the traffic stop, I had requested another officer respond to assist me. Officer A. Ivy arrived a short time later. Once Officer Ivy arrived on scene, I advised the female she was under arrest for a defective headlight and for failure to identify a driver of a vehicle. I was able to open her driver door, reach in to unclip her seatbelt. She then told me she was not getting out of the car. I then utilized a technique known as a wrist lock and arm bar in order to immobilize her. I reached in and pulled her from the car and down to the ground. Once the female was out of the car and on the ground, I was able to place her in the handcuffs with no further force needed. At one point earlier in this incident, I requested Central Dispatch check the vehicle registration to determine who owned the car. The registered owner was discovered to be Helen K. Reyes. This name was also checked for warrants and found to possibly have an outstanding arrest warrant from Beaumont PD. Due to Reyes intentionally refusing to identify herself while operating a motor vehicle, she was arrested for defective equipment headlight and failed to identify a driver and the warrant. Her vehicle was released to a family member at the scene. Only after the female was placed under arrest is when she confirmed her name as being Helen K. Reyes. She was also confirmed as being the Helen Reyes that was currently wanted from Beaumont PD. Both in my car and body-worn camera recording during this incident. This incident occurred in Port Neches, Texas, which is located in Jefferson County. Again, stuff not listed in the complaint.
Exactly.
Hey, Helen, you not requested the body cam footage?
I did, and I've been denied all of it from both. The Bradley Law Firm in Port Neches sent me a long certified mail clipping as to why I shouldn't have access to any of that. They denied me access. I asked the in writing to the Jefferson County Court at Law Number 2, their a district attorney that's the prosecution. They've also denied me, and they're still using 39.14D in the pretrial hearing last week, that they're not going to release that, and they're going to continue to use a statute to override the 14th Amendment. Yep, that's what they're going to do.
Isn't that a due process violation, Eddie?
Yep, and I made it clear.
Is, but here's the other problem. You see this line I've got highlighted here?
At the bottom of that probable cause?
Yeah. Failed to control speed, collision. He's saying you had a collision.
Yeah, didn't. Where?
Now, the only problem we've got is this isn't signed. This is his incident report. It is an official record, but it's not signed.
Correct.
Okay? But the problem is, it's an official record, whether it's signed or not. And this official record appears to contain a false statement.
Yep. And we proved that, Eddie. That's not even the situation anymore. That completely dissolved itself when we turned in that motion to Beaumont. They had to let it go. And they messed up big time. But they got caught. But that doesn't stop them from doing it over and over.
All right. Well, whether or not you identified before he told you were under arrest is rather important. See, this is what I was getting about why it's important to protect yourself by asking the right questions, not making statements about who you are and why you aren't applicable to blah, blah, blah. You ask questions that are meant to invoke, demand, and protect your rights. That's it. Anything else is speaking out of school. Period. You guys need to understand that.
Yeah.
If
I
you
know.
fucking panic and speak out without thinking, you're going to get yourself in hot fucking water every day.
This wasn't even part of that wasn't even brought up at the pretrial. So
It's irrelevant. It's what resulted in the failure to ID charge. So yes, it was brought up, just not in those terms.
right.
Had you stayed strictly with what I suggest you say relating to, can any of the information you're demanding be used against me or to potentially incriminate me in any way? Stick to that, and your bases are covered. Because now you have a legal argument that they wrote a statute that is attempting to compel me to incriminate myself to further criminal charges, potentially. And I'm not going to do that, statute or no. That would give you a defense against the charge that they're going to have real trouble trying to just whisk away. You get it? Do not do what he's talking about here.
Yeah.
Do not do this. Don't argue the fucking transportation code on the side of the road, guys. I'm trying to get you to understand that for years now. Don't do that, okay? You're trying to be the bear. You're not. Not in that place, okay? Don't do this. You know why? Because this is what they use it for. Right there. Now the question is has the court seen this? If the judge has read that, that's prejudicial. It'd be the same thing as if the police officer wrote it on the back of the citation after giving you a copy.
Right.
And then gave a copy of that to the court. That is stuff they cannot do. So by putting this in here, and if the judge has seen this, we can move to disqualify the judge.
Move to disqualify this judge right now?
No. The first thing you have to find out is whether or not this judge has read this incident report.
How would you go about determining that?
Yeah.
Well, that would have been something she should have asked at the last encounter. Now she's got another pretrial. She can ask the judge there. Normally she doesn't get 2 bites at that apple.
Right.
Okay. Things you guys need to understand. Number 1, you get a document relating to a case that you're involved in. You read that motherfucker multiple times till you can recite it in your fucking sleep and you know everything that's in it and what it requires you to do or not do. Period. When you don't read something, that's the thing that will always come back to bite you in the ass when it comes to this type of stuff. Because these documents will contain deadlines, they'll have filing requirements, they'll have all kinds of shit in them that give you notice of things you're required to do or to respond to or to make sure you understand and to have available or to bring with you or to ask for. And if you haven't read it, you're not doing any of it. And if you're not doing any of it, all you're doing is creating even more problems for yourself, especially if it's something they turn around and say, the court ordered you to do this, you failed to do it, therefore I'm holding you in contempt. Do you get it? Now, they say very clearly their body cameras are recording. They're supposed to turn that over.
Yeah, they refused. And remember, I was showing you that the Bradley Law Firm Report H has sent me a whole bunch of crap.
Yeah, that would be the law firm this guy works for, right?
No, this guy that was prosecuting my case, he does not work for them. He has his own law firm in my town. They call him Buddy Stevens. In fact, I can look him up for you.
I don't care.
Have you filed a motion to compel for that evidence yet?
Yeah, I already did that. And the prosecution still held to their word, even though I showed them it was
Well,
also
you don't
a break.
file it in the same court. You file it with a higher court. You file it to a court above these, like the county court at law, for example. You file a motion. Well, actually, you can do it either way. If you're trying to compel the police department, you file it with the court you're in. But if you're going to file it against the court you're in for not forcing the police department to comply with the law, then you have to file a writ of mandamus. And that has to go to a higher court. And it can't go to the county court at law. It has to go to the appeals court. Because the county court at law are actually, hang on just a second. That's something else I need to verify.
What I did right now is I went ahead and filed it with this case right now that the district attorney has to send over, because they have copies of everything that was sent over from the lower court. I have to have access to that in order to prepare for.
Okay.
So are they trying to keep the body cam away from her because they're not going to use it as evidence, or would that be
Oh no, they're going to use it because they played it throughout the whole damn pretrial.
Then isn't that a Brady violation?
I told them that in there. I said, I need, hey, wait a minute. I don't have access to this, and I've been denied, and you guys have said that 39.14D is the driving force, and that you've given me all these opportunities. However, 39.14A is the main statute that must be followed. And I said, that's the Michael Morton Act, and without providing me that information, that's also a Brady law violation. That's a due process violation. I mean, it can't get more hard-headed than this.
So in the lower court to upper court, as far as if I'm dealing with a district court, would I have to go above the circuit court to try to get the information?
You have to go to whatever court above them has mandamus powers if you're looking for a mandamus.
Okay.
And not every court above them may have mandamus powers.
We would be the superior court after the circuit court in Arkansas.
Well, that may be the next higher court, but does that court by law have mandamus powers?
Roger that. I will research. Thank you.
All right. Right here. Government Code, Chapter 22.221, Writ Power. Each court of appeals or a justice of a court of appeals may issue a writ of mandamus and all other writs necessary to enforce the jurisdiction of the court. Okay? So that is not the county court at law. That's the appeals court above the county courts at law. Subject to subsection C1, each court of appeals for a court of appeals district may issue all writs of mandamus agreeable to the principles of law regulating those writs against a judge of a district, statutory county, statutory probate county, or county court in the court of appeals district. Each court of appeals for a court of appeals district other than the court of appeals for the 15th court of appeals district may issue all writs of mandamus agreeable to the principles of law regulating those writs against a judge of a district court who is acting as a magistrate at a court of inquiry under Chapter 52 Code of Criminal Procedure in the court of appeals district, or an associate judge of a district or county court appointed by a judge under Chapter 201 Family Code in the court of appeals district for the judge who appointed the associate judge. The original jurisdiction of the Court of Appeals for the 15th Court of Appeals District to issue writs is limited to writs arising out of matters over which the court has exclusive intermediate appellate jurisdiction under Section 22.220D. Concurrently with the Supreme Court, the Court of Appeals of a Court of Appeals District in which a person is restrained in his liberty or a justice of the Court of Appeals may issue a writ of habeas corpus when it appears that the restraint of liberty is by virtue of an order, process, or commitment issued by a court or judge because of the violation of an order, judgment, or decree previously made, rendered, or entered by the court or judge in a civil case. pending the hearing of an application for a writ of habeas corpus, the Court of Appeals or a justice of the Court of Appeals may admit to bail a person to whom the writ of habeas corpus may be granted. So according to this, the courts of appeals are the only mandamus courts we have in Texas.
Okay.
So whichever appellate court has jurisdiction over where this court is located that you're in now, that's who you go to. Third Court of Appeals, Fifth Court of Appeals, whichever one it is.
He's the one upstairs. I forget which Court of Appeal that was called, but yeah. He said, every time you're going to, and that's what the judge said, he said, anytime you guys are going to appeal, it's going to go right upstairs to the appeals court.
Right. Well, so we made the argument in one of your pleadings about their misinterpretation of the Michael Moore Act.
Yes, we did.
All right, so you need to put that into its own individual writ of mandamus brief.
Oh.
And you need to file that and make sure you follow the proper format for a Court of Appeals brief. Okay? So
do we need to do that now?
Yes, because they're not giving you the evidence you need to defend yourself.
Oh, I need help writing something like this. I guess I need to contact Jane.
I don't know if I'd go quite that way.
No, I was fixing to say, God, I didn't think you were going to put me up on the noose like that, but
the you need to take whatever we argued regarding the misinterpretation and application of the Michael Moore Act and put that into its own brief, but the brief has to be formatted according to the rules of appellate procedure for briefs.
Okay. Now I'll find that.
File it as a interlocutory appeal and writ of mandamus.
Interlocutory appeal and writ of mandamus. Okay.
Okay, so this means studying the rules of appellate procedure to figure out exactly what format that has to be in.
Okay.
It'll tell you font size, line spacing, margins, binding covers, and you have to put bindings on some of these. For instance, in the county court at law, my appeal had to be bound in 24 weight turquoise blue bond paper covering. Why? Because that's the format they want it in. And then when it goes to this Court of Criminal Appeals or the Court of the Texas Supreme Court, it's got to be leather bound.
And what does the binding signify?
Pompous assholes that think they're special and should get something from us, regardless of what we do.
It's the ancient Babylonian magic's what it is. Some Patreon that stuff.
Well, see, now I have
Supreme Court judges can't possibly be expected to read anything that's not leather bound, right?
Correct.
Why in the world would a Supreme Court judge read a fucking paperback?
But couldn't you find the same kind of information in a paperback that you could in a leather?
You would think so.
And how can you subject or be so subjective to say that paperback may have more information than that leather could ever give?
If they're the same book, it shouldn't. Because then you're talking about two different editions of the same book, not the same book bound in a different cover.
Mm-hmm. What's more important, the cover or the information inside?
Well, I guess that depends on where you're sitting, doesn't it? To them, apparently it's the cover because it's the reason they reject looking at any of it. If it's not bound according to their rules, they won't even look at it. They'll kick it right back and say, this isn't proper. Don't send it to us like this.
But wouldn't that also be prejudicial in nature?
Again, separate issue from how they want it. Okay, this is why they want you to hire attorneys, because attorneys know these things and attorneys do these things because they know they're required to do these things. But you're going to pay handsomely for them to do it. In any case, you're hemming and hawing about all this stuff and you haven't done the assignment I've given you about defending yourself against this complaint.
And I've already told you my answer. I'm not yet ready to think on my feet, but I am ready to
Well, I want you to sit here and practice it so you can try. Here's what you've got to argue with. Okay? It's right in front of you. It's not like you're going to forget mid-sentence. It's right here. Just figure out the questions you need to ask to show that I can't prove it.
All right, and then so maybe like, officer, now you state in your complaint that you and I met for the first time on January 28th of 2024, is that correct?
I didn't write the complaint. I didn't even sign the complaint.
Well, see, now that's questionable. But he's the one that
No, it's
wrote
not. Do you see his signature down here anywhere? This one says affiant deputy clerk and this one says court clerk. Do you see his signature on this complaint?
No, so then it
Do you
can't
see
be,
his name on this complaint other than
is
up here?
information provided to me by Eric Allman.
Right, provided to me by this person, which means it's not this person.
So then it is questionable as to whom created that complaint then.
No, it's not questionable. It's just simply a fact that he didn't do it. And that's what I just said. I didn't write the complaint and I didn't sign the complaint. Because that's the question you asked. Was what in my complaint? It ain't my complaint. I didn't write it and I didn't sign it. Therefore, what does that tell you about the formulation of your question?
That it's not going to be credible, or it's
not a good question. At least not formulated the way you've done it.
Right.
Rethink it. Try again.
So, well, let's see. So, officer, you per your affidavit, that was his affidavit of probable cause. Then couldn't I ask questions on that he did create and that he did sign?
Say it again.
So you want me to ask questions on the complaint, but he didn't write this complaint, right? So
why does the fact that he's didn't write it stop you from asking questions about what's in it?
How about, officer, when did we meet first?
Okay, why is that relevant? Why is that question at all relevant to what we have right here?
To showing the time of day, which this is just blown wide open. It doesn't show anywhere in the complaint what time of day it was. You know, like I said,
but right. we can get that based upon what it says right here. Right? Those two, that one sentence right there will cover that. The complaint says during a time at least 1/2 hour after sunset and at least 1/2 hour before sunrise. In other words, the complaint does not specify any given time for when this alleged offense occurred.
Yeah. Okay, so officer, when you pulled me over, do you remember what time of day it was?
Again, how is that challenging the validity of the complaint?
You're giving him...
All you're doing is giving him the ability to testify to an element they need to prove. Oh. And now you're getting him to prove it for them.
Oh, okay.
So if the prosecution fails to ask it, and then you ask it, you fixed it for them.
Yeah.
Okay?
Yeah. I mean, I sort of see that, but...
Okay, let me show you something else here real quick.
Okay.
Let me pull up another statute here. Indictment and information. Requisites of an indictment. Okay? An indictment shall be deemed sufficient if it has the following requisites. It shall commence in the name and by the authority of the state of Texas. It must appear that the same was presented in the district court of the county where the grand jury is in session. It must appear to be the act of a grand jury of the proper county. It must contain the name of the accused or state that his name is unknown and give a reasonably accurate description of him. It must show that the place where the offense was committed is within the jurisdiction of the court in which the indictment is presented. The time mentioned must be some date anterior to the presentment of the indictment and not so remote that the prosecution of the offense is barred by limitation. The offense must be set forth in plain and intelligible words. The indictment must conclude against the peace and dignity of the state. It shall be signed officially by the foreman of the grand jury. What should be stated? Everything should be stated in an indictment which is necessary to be proved. Okay? The certainty required. The certainty required in an indictment is such as will enable the accused to plead the judgment that may be given upon it in bar of any prosecution for the same offense. In other words, it has to be certain enough to prevent double jeopardy at some future date. Okay? Now, why are we talking about indictments? Well, because indictments is the only place where the specific requirements are listed. Then we go down here to informations. Let's see. Requisites of an information. An information is sufficient if it has the following requisites. It shall commence in the name and by the authority of the state of Texas. That it appear to have been presented in a court having jurisdiction of the offense set forth. That it appear to have been presented by the proper officer. That it contain the name of the accused or state that his name is unknown and give a reasonably accurate description of him. It must appear that the place where the offense is charged to have been committed is within the jurisdiction of the court where the information is filed. That the time mentioned be some date anterior to the filing of the information, and that the offense does not appear to be barred by limitation. That the offense be set forth in plain and intelligible words. That it conclude against the peace and dignity of the state, and that it must be signed by the district or county attorney officially. The information must be based upon the complaint. No information shall be presented until affidavit has been made by some credible person charging the defendant with an offense. The affidavit shall be filed with the information. It may be sworn to before the district or county attorney who, for that purpose, shall have the power to administer the oath, or it may be before any officer authorized by law to administer oaths. Rules as to indictment apply to information. The rules with respect to allegations in an indictment and the certainty required apply also to an information. And since the information must be based upon the complaint, the information in the information must be taken from the complaint. Right? Therefore, the complaint must have all of the same requisites as an information or an indictment do, because they are both based on the requirements of an indictment. Okay? That is connecting the dots. Right. None of these three documents stand separate from each other. Right. None of them. No. Okay? This is the problem with them using just a complaint alone.
Right.
Okay?
Right.
So, this is why they say they can use a complaint, but this is why the Constitution and the statutes say they can't. Now, back to our complaint. Our complaint does not state, let's see, and here is the requirements of the complaint out of chapter 45. So let's go back to chapter 45 here real quick. Or what is now 45A. Complaint. All right. A complaint is sufficient without regard to form if the complaint substantially satisfies the following requirements. 1. Is in writing. 2. Begins with, in the name and by the authority of the state of Texas. Either states the name of the accused person or, if the name of the accused person is unknown, includes a reasonably definite description of the accused person. Either shows that the accused person has committed an offense against the law of this state, or states that the affiant has good reason to believe and does believe that the accused person has committed an offense against the law of this state. States the date the offense was committed as definitely as the affiant is able to provide. Bears the signature or mark of the affiant. This used to say the date and time the offense was committed. Okay? Concludes with the words against the peace and dignity of the state. All right? So, it no longer requires that the time be specific. But it does require that it, as definitely as the affiant is able to provide. Well, we don't know if that's as definite as the affiant can provide. We don't know if what's in here is sufficient to do that. We don't know what the clerk knew who signed this. They're the affiant, not the officer. Okay? But there is no time stated in the complaint, so I'd attack it nonetheless. Plus, again, they're being non-specific. Well, either it was at the wrong time of the day or night, or it was when light was insufficient. Which is it? How do they prove that it was insufficient and not visible up to 1,000 feet away? How do they prove that? Or when light was insufficient or atmospheric conditions were unfavorable so that a person or vehicle on the street was not clearly discernible at 1,000 feet away without having... All right, we don't need that, okay? So, what questions can you ask to determine whether or not the 1,000 feet requirement was met?
What was the weather like the night of...
That's very general. Can you be more specific?
Okay. Was it raining?
No.
Was it foggy?
No.
No.
Now, what's between rainy and foggy?
Was it clear?
Yes.
Okay. So,
And by the way, misting is between rainy and foggy.
foggy, right? Yeah, it was clear that night, or whenever that time was.
So then your question, the only question you needed to ask was the weather clear
Clear.
on the night in question?
And the answer would be, of course. Okay.
Okay. And how did you measure the distance from where you first saw my car to where you were parked? That would be my follow-up question.
Yeah. Oh, how he measured the distance? Well, he said, I used my line of vision.
Okay, and what do you do when he says that kind of bullshit?
Officer, how were your eyeballs calibrated to detect the distance?
Yeah. Do you wear glasses?
Let's don't say it so snidely. Ask it in a way that they can't possibly answer it in a way that would make sense. But don't do it. You don't have to do it snidely. Okay. Officer, can you please explain the calibration method required to calibrate your eyes to measure exact distances after sunset? And can you tell us where the policy manual has those instructions?
I see where you're going with that. Oh, God.
Did you take an exact measurement of the distance from where you saw my, say you first saw my car to where you were parked to determine the actual distance?
And he testified, about 400 feet.
But again,
How did
is
he
that
measure it?
Is that, yeah, how did you determine that exact distance? And are there any physical barriers or obstructions that would have prevented you from seeing it at a greater distance from where you were parked? Is there a hill? Is there a crest? Is there a building? Is there a tree? Or is there a hedgerow? Is there a billboard? Is there any obstacle between you and where you first saw my car that is more than that would interrupt your line of sight for more than 1,000 feet?
No.
Again, officer, how did you determine that distance as to know what 1,000 feet is? Have you measured from where your furthest point of view is to where you were parked to ensure that you knew exactly how far that would be? Do you have actual markers for distance laid out in a succession to mark the distance between you and the direction you were facing so you can determine accurately the distance involved?
No, I just used my line of sight.
In other words, you guess.
Yes, that's correct.
And just by guessing, one could say, you don't know what the actual distance is. You just guess.
Yeah.
Okay. So, and then you get him on. Can you please tell us the distance from where you're sitting to the rear of the courthouse, please, or to the rear of the courtroom? Bring a tape measure. Play My Cousin Vinny.
Right.
Okay. Let's see how accurate that is. All right. Now, without having at the front of said motor vehicle at least 2 lighted headlamps. Now, officer, the complaint specifically says that I did not have 2 lighted headlamps at the front of my motor vehicle, and then it cites 3 specific statutes and sections of statutes: 547.302 AC, 547.321, and 541.4015 of the Texas Transportation Code. Are you familiar with these statutes?
Not off the top of my head. That's what he testified to.
Not off the top of your head, but you knew on the night in question that supposedly these statutes required 2 functional headlamps on the front of a car. So how could you know that if you're not familiar with these statutes?
Yeah, and he testified, get this.
Stop. Pay attention to what I'm asking you.
I know where you're asking.
Well, then play the part. Help everybody else out.
Well,
What did he say?
I didn't read them. I don't remember them, but I know it was off the Texas Penal Code and the Transportation Code of what I've read and had to review before the start of each shift. We have to.
Okay. So you're saying, is it your testimony? If I'm hearing you correctly, is it your testimony that you review each of these statutes at the start of every shift?
We're quizzed on them all the time.
But that's not what you said. You said at the start of your shift, you have to review.
Yes.
So, my question to you is it your testimony that at the start of every shift, you read these statutes?
Well, we're quizzed on them by our supervisors.
Before every shift?
Yeah, every day.
Then you should have more than a passing familiarity with these, and you should be able to recall them if you're required to recite them from memory every single day before your shift begins, correct?
Yes.
Then why is it today here in this courtroom you haven't looked at it in a while? You don't remember. You don't know exactly what it says since the last time you read it, but why is that, officer?
Oh, it's just been a long day.
It's been a long day. Well, it's been a long day for everyone. But let me ask you this. Are you absolutely certain that you are familiar enough with these statutes cited in this complaint to know for a fact that these statutes require 2 lighted headlamps on the front of a car after sunset and before sunrise?
Well, no, not off the top of my head.
Well, again, you've already said it's not off the top of your head. You're quizzed on this every single day. You said you know this every single day when your sergeant asks you at the start of your shift. So why don't you know it when we're in a courtroom and you're trying to prosecute me for them? Why is today the dawn of the stupid?
Would you really say that?
I would. Or the dawn of the dumb. Or the dawn of the deaf, dumb, and blind.
Yeah, but then again, that could get.
Or why is it today that you developed Alzheimer's? Or dementia?
Isn't that prejudicial?
No, it goes to prove that he's either lying to us or his memory can't be trusted. It's got to be one or the other. It can't be both. Well, it could be both, but in either case, it proves that his testimony is not trustworthy. He's either lying because he says I have to have it every morning and know it, and yet right now when I'm here testifying about it, I don't know it. Or his memory's bad and he can't recall shit from moment to moment. In either case, his memory's unreliable. You get it?
Yeah.
Okay.
I see how you attack it.
Now, the complaint also says that my lights are not mounted at the proper height of 24 to 54 inches from the ground. Can you please tell us when you took the time to measure the exact distance of my lights from the ground?
I did not measure it with any measuring. I just looked at it with my eyes.
Oh, the same eyes you used to measure the distance you spoke of earlier, that when we marched with a tape measure to the back of the courtroom, you were off by 35 feet?
Yeah.
Those eyes?
Yes.
Okay. So we know at this point, we've determined that 1, you need eyeglasses, and 2, your way of measuring things is always just your personal opinion and best guess, and not with any actual measuring devices.
Right.
So it would be fair to say that you have absolutely no admissible evidence other than your opinion of how high a light is? Is that your testimony?
Yes.
Okay. Well, I thank you for that. Hang on a second, guys. Okay. Now, these 3 specific statutes, or sections of statutes, I would like the court to take judicial notice of 547.302 AC, and I would ask the court to take particular notice of the fact that 2 lighted headlamps, that language does not appear anywhere within that section of that statute. Then I would like for the court to take a look at 547.321 and take judicial notice of the fact that that language does not appear anywhere in that statute either. And 541.401 subitem 5 also does not contain any such language. Now the complaint says that said motor vehicle at least 2 lighted headlamps. They're making 2 lighted headlamps a requirement where the statute does not. The state cannot prove the statute requires 2 lighted headlamps because that language doesn't exist. The language specifically differentiates between the general term lamps and the specific term headlamp. And in relation to the reference of two lighted lamps on either side of the front of the vehicle, it uses the general term two lighted lamps, which is applicable to any of the collection of lamps required to be installed as equipment on a vehicle. Now, Officer Hellman, was there at least a turn signal operational on both sides of the front?
I didn't observe.
You didn't observe. Was there at least a running light or a fog light on each side of the vehicle on the front?
I don't recall.
You don't recall?
No.
And yet you're in here testifying that I broke the law, yet you can't recall where the law says what the complaint says. You can't recall exactly what lights were on and what lights were not, though you're absolutely positive one of the headlights was not on. Is that your testimony?
Yes.
Okay. So you were focused on the fact that there was one headlamp allegedly not on and insisting the law required it, and yet you can't provide the statute that says it.
Correct.
And nowhere in the statute cited in the complaint does that language exist. Correct?
I haven't read the statute in its entirety.
Actually, you have, because we just gave the court judicial notice of it. Okay? And you're testifying to it, therefore you're presumed to know what's in it. You don't get to say, I haven't read it, but I'm going to testify to it anyway. So which is it? Are you lying about what you know or what you think you know in order to get a conviction to justify a stop that you made illegally because there was no law to base it on?
I guess. I guess I just went off my own opinion.
Objection, Judge. Non-responsive. That's not an answer to the question that was asked.
What could he say?
Let me simplify it for you, officer. Are you lying to the court about what you know the law says? Are you lying to the court about what your understanding of what the law says? Are you lying about how often you've read the statute in order to know what it says? Or are you just lying to rack up an arrest record that you can use for promotional purposes?
This is really good. I didn't think about that. To prove to the court he's lying at every interval.
You don't have to prove he's lying. You just have to prove he doesn't know what the fuck he's talking about.
What he's talking about.
And his memory cannot be trusted.
No. You're attacking his credibility.
And his opinion is not admissible.
Right. His credibility is null.
That's the goal. See, you guys want to argue over the wrong things every single time. Rule number 1, destroy the credibility of the witnesses. The opposing counsel's witnesses. Build up yours if you have any. Destroy theirs at every opportunity.
And I'll add, Helen, right? I mean, like when Eddie read that they arrested you for the silliest thing in the entire world, you know how humiliating and how just despicable this guy has to be to actually have arrested you for such a minuscule piece of crap?
Well, number one, it's like, not an arrestable offense. So that right there.
It was.
Well, they arrested you.
Okay, but, stop. Any offense is arrestable, according to the United States Supreme Court. Even a civil offense is arrestable.
But the problem is this isn't an offense codified.
The failure to ID is, and that's what he's going with first.
Yeah.
But, what I'm saying is just like the same way with me. I'm the same way. Is that we give so much power to this imbecile cop that took a lady and arrested her.
Oh yeah.
Just he is an incredible idiot.
Well,
and
that's
so why
that.
not tell the
That
court
is a
how
training
idiotic that he
deficiency.
is? What?
That's a training deficiency. We
Yeah.
do not require cops to know enough to be cops.
Right, I agree.
We don't.
Okay?
And my husband
and
and my
simple.
brother-in-law were both shocked.
There is no way a cop should ever be allowed to become a cop with less than 2 years of training.
Right.
They should have to go to school, real school, for 2 fucking years minimum.
Or something.
Yeah, but we can't get that changed until we make a proper argument to the training, I guess, to the state to get that changed to where their training has to be for a much longer period of time and what
And
they
much
should be
more
trained.
diverse.
Yes, and trained to work in all
And statute specific.
and
if
constitutionally
they invest that much
specific.
time, they're not going to get anybody because, like, there's only a certain
Exactly.
amount of people that's going to be a cop.
No,
But-
they'll get people, but they'll start getting people with an actual fucking IQ above double digits.
Yeah, but it's like I've just been listening to what you're saying. Helen needs to put a bite. I mean, like, Eddie, you were really good, right? I mean, like,
Right.
you were on point. I mean, I don't even think I could remember all this stuff.
No.
But some of the part is you gotta put a bite into your defense. I mean, Eddie was like, "Hey, I'm taking you to task," and we always try to give, excuse people for what they do, or well, we're gonna help them out, and we're gonna, no, make him be the fool that he is, that he actually arrested you and tore your life apart and is putting you through all this crap. This guy's an idiot. And so show the court that he's an idiot and put a bite in it. I'm not saying it's going to be easy, but, I'm just being
Just chip away at his credibility is what we're doing. We chip
Well, I think you go beyond his credibility. I mean, he arrested you for some minuscule piece of crap.
Well,
My
for one
God.
thing,
Well, here's the thing, okay? This is what I was talking about last week when I said, at what point does an honest mistake of law become willful ignorance to cover your ass?
Right.
That's what this goes to.
I just
Now,
can't
if you get that cop to say that he's been quizzed on these statutes many times and he's required to know them every day before he starts his shift, you get a cop that's dumb enough to say that shit on the stand and then says, "I don't know," right after that, he just dug his own fucking grave in the credibility department.
yeah, and that's the grave he wanted to dig for me.
Okay? And therein lies the problem.
That's right, Helen. That's what he did to you. Right? He did that to
He
you.
dug the grave for me so he could fall face first in it.
Well, no, he just, I mean, like, I think that I've been, like I said, I've gone through the Ritter, so it's like beyond me, but he did an injury to you. You've been injured and hurt badly. And
Yes.
this guy, don't give him any more credit. Think of him, try to think of him as the person that he is. He hurt you, right? He went out of his way to hurt you by making this silly old thing that just, you didn't have to be hurt like this. You didn't have to spend all your time to defend this.
But
He's
then
hurt
again,
you.
I have to do it in a way that I can't show that emotion.
Well, I listened to Eddie. Eddie was like, he
No.
didn't put emotion in it. He basically,
Now, passion and emotion, two different things.
yeah, he put this thing to task, meaning that he made the cop look like a fool, right? But don't save him. Don't try to save him. Go after him like the little
The
piranha.
wuss that he is, the coward.
Yeah,
that
he hurt
is.
you. He hurt you. He put your life a mess. He put you in chaos. He's made you learn all this stuff and defend for yourself. He did that to you. You don't
Yes.
deserve to give him any help at all on his own. Stop giving him help. Stop giving him input.
No, stop giving him any rope. Let him hang himself.
Well, he already did when he hurt you. He hurt you. I mean, it's like, I know that something like you, like, because I've been through the same thing. I'm like a tank or something. Like, yeah, you could do all this stuff to me, but I sitting back and I'm like, can you believe this person hurt you and put you?
But it's not just me that he's hurt. He's been doing this over and over and over to the public.
Okay,
That's the problem.
then when you go to court, you're a piranha, right? You know, he should. This guy doesn't deserve, right, the help you're giving him. He doesn't deserve that. He doesn't deserve to, like, oh well, you know, like, I eyeballed it. Well, what measuring system were you using? Because we have the international measuring. If I go to work, I can't just say, well, I just eyeballed it. No, I've got to use a ruler, or I've got to use a torque, right? I can't just say, well, it's that. I mean, can you imagine you use anything like that, right? It's just top of my head, I just used it. Well, you know, I mean, how would you like to sit in a chair that you don't know how high it is or how low it is, right? Or anything. You have to have a measuring device, but it can't be an opinion. You got to go after that, right? I mean, you've got to show him what he really is. He hurt you in a terrible fashion, arresting you, embarrassing you, right? You know, like you have to defend for yourself for a stupid headlight. I mean,
okay. We've beat that horse.
I'm sorry. Okay, I'm done.
So what you need to do, Helen, is you need to take this part of the complaint that I've got highlighted here. You need to outline it in a document, in a Word document. Just break down each of these parts that we need to ask these questions over, and lay out your questions in a logical sequence to show they can't prove this part of this complaint.
Okay. I've got an idea on what I can do, so I'll be doing a bit of research pretty quickly, and I was hoping maybe some of the friends here in the class might want to help. I do know of one.
Helen, are you using AI yet?
Yeah, I use it sometimes. I just use it very sparingly and carefully.
I'm telling you, get on GPT.
Be careful with that.
I use it all the time. I'm still alive.
Yeah, I know, but we got to be careful because there's a lot of things out there that are not correct.
I understand, but what it helps you do is kind of vomit your thoughts onto the page, and it'll help you It'll help you organize them in a way, and you can vet them afterwards. At least you have a structure to work with.
Oh yeah,
that's what I mean.
That I do know.
Okay, so
Julie, Chris, hang on.
Julie helps.
Julie, are you still here? If you're talking to her, take the complaint that we've been looking at for you here.
Yeah, I'll send it to her.
And then she can just copy the text and use that to make an outline of it. If I could copy this from here to put it in this Word document, I would, but I can't, and I'm not going to sit here and write it all out again. That said, we are down to where anybody have any questions or comments or anything like that before we get rid of tonight's class.
Eddie, I got a question from earlier on in the class, and you're talking about what happened to Helen when she was getting pulled out of the car. You were reading her, you were actually reading the police report or the police complaint.
Right.
And he said he put her under arrest. He actually verbally said to you, Helen, that I'm putting you under arrest. You're under arrest?
Yeah.
Okay. I'm curious how much of that is a requirement before they handcuff you. Like, do they have to verbally say?
They have to put you under arrest before they handcuff you unless they can articulate facts that make them believe that you're armed and dangerous, and that's the only way to protect themselves from you.
Okay.
Then they can do it when they detain you. If you're acting the fool or they believe you're armed and dangerous, they can handcuff you during a detention. Otherwise, they're not supposed to do it.
Okay. So I've got an attorney that's supposedly representing my police case. And she talked it up, hemmed and hawed, and then she says, actually, I'm liking it more and more. We get, it's, the case that you have. And then today she kind of wants to settle for a small amount and can't really articulate why. But anyway, that's the backstory. But as I'm hearing these details, the thing that's in concern is whether they had a reasonable suspicion. And I've seen case law from the Supreme Court that just having a hunch or just knowing somebody or wanting to see if there's a crime doesn't give you probable cause or reasonable suspicion to go fishing for a crime. They have to articulate what the crime is.
No. That's they can fish all fucking day long. What they cannot do is illegally detain you without articulable facts of an actual crime to detain you for. What they cannot do is arrest you without actual probable cause of criminal conduct.
Right. And so the sergeant backed up his police, said, you were under arrest. Because I said, what happened? Because nobody said anything about that I'm under arrest. He says, no, you were under arrest. I said, okay. And as you were talking about Helen, they never said you're under arrest. Get out of the car. Put your hands behind your back. They just opened the door, ripped me out. And part of the argument was it's for their safety, but then they double handcuff me because I'm such a threat, right? So I'm trying to piece this together to wrap my head around what my rights are if I ever talk to another attorney, because I don't see any judge saying they had reasonable suspicion to check your ID for a crime when they couldn't articulate the crime before they had to go fishing for it. Right.
They don't. That's the thing. There is no such thing as a stop and ID state without articulable facts in support of criminal conduct specific to the individual whose ID is being demanded. It can't be general. It can't be a hunch. It's got to be something specific to the individual they're wanting to identify. And here in Texas, even if they detain you, you're not required to identify. You're only required to identify if and when they say you are under arrest, or, since they amended the statute, you're operating a motor vehicle.
Yeah. Okay, so this back to the question about the kind of like the order or sequence that you're knowledgeable of what's going on. At least in Helen's, it sounds like he was bulldozing her rights from the very beginning because he didn't understand any of the statutes he was trying to enforce. He was just thinking he could do it. But he did start a sequence of saying you're now under arrest, whatever, and then manhandle her. Does that at least give the person, the defendant, the victim, certain sequences of knowledge so they know what's happening so they can react?
You can't assume you're under arrest until someone articulates the fact that you're under arrest. Okay? But the part where Helen got this wrong is, because we've discussed this numerous times, is that a traffic stop in Texas is a custodial arrest from the moment the lights come on. It absolutely is a custodial arrest. That's why saying I'm not this, I'm not that, blah, 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 isn't helping you. But what will help you is, if I'm under arrest, then I want my right to counsel. And I can't give you any information or answer any of your questions until I have done so with proper permission from my counsel. That includes giving you my fucking ID and driver's license. Because you can use those documents against me later in a court of law or to potentially incriminate me for some other offense. Think about it. What can they charge you with on a driver's license in addition to the license being expired?
Not having the right address, or not
the right address, not wearing corrective eyewear, etc., etc., etc.
Or your birthday's wrong, or whatever's wrong.
Well, your birthday may or may not be wrong, but it may show that that's the reason it's expired.
Right.
Okay.
And it could be anything on there that's, printed.
Yeah, they could not like your blood type. All right, so the problem there is they're forcing you to give up information that could be used to potentially incriminate you in other ways.
Self-incrimination.
Okay, they can't order you to do that. That's why we challenge that change to the statute as being unconstitutional on its face.
And I don't think
did the Attorney General ever respond back to defend it?
No, they haven't.
Okay, then they have a problem.
Yeah, they do. But will they ever respond to the defendant?
Well, if they don't, it must be taken as true that the statute that it's being challenged is unconstitutional. If there's nobody there defending the constitutionality of it, which is the Attorney General's job, then how's the court going to say it's constitutional?
Yep. But the court may take that as, oh, well, we didn't hear anything.
Yeah,
so.
but here's the problem. That is the court now stepping in to represent the state to keep the statute intact when it has been specifically challenged. That's a conflict of interest.
So then I could object to that.
Yes, you can.
At this next trial conference, I need
This
to be
judge has no power to determine the constitutionality of the statute.
But what I need to ask is, did the Attorney General answer to them at all or make any effort? Because I checked with the court clerk and they haven't received anything either.
You can ask.
I did ask, but I don't think there's anything on there. I can go back and ask again and see if there's been any response.
Did the court clerk affirm that they had sent it to the Attorney General's office?
Yeah, they actually sent me a copy of when they sent it. They sent me an email showing that they sent it.
Okay.
Yeah, they emailed it to them, electronic.
All right.
Yep. I've got a copy of it too.
Well, then you've got proof they've received it. If they don't show up in court, they're fucked.
Yep.
Because now that takes away the failure to ID portion of the charges, and this cop's dead in the fucking water.
And that's the thing. So at pretrial conference, they may decide to just throw this whole shit out because I made that damn constitutional challenge. That is a possibility.
It is possible. And then on appeal, if they don't, and we go to appeal, the first argument we make is abuse of discretion.
Yep.
Okay. So, given that, what else? Chris, did we get you an answer to what you were asking?
Well, we're getting there. I'm piecing it together. I'm just trying to understand. I don't have the case in front of me, but there is a Supreme Court that, remember the guys that were the cops that were waiting outside of a bar. They knew a guy because he had a previous record, and they decided to use that as a.
There's Terry v. Ohio. There's Pennsylvania versus Mims. Those are the ones they normally like to use.
Yeah, it's like a Hobbs or something. It started with an H, I thought.
There's a Hobbs case as well.
Okay. And the Supreme Court clearly said that just because you know somebody and you think there's something suspicious, if you can't put your finger on it, you have no right to stop somebody and ID them. And that's what they did, and they explicitly ruled on that. And I'm trying to come up with the argument. We don't have to do it tonight, but I'm just trying to come up with the argument of how the hell can a judge. Apparently, the judge is going to rule on whether they had reasonable suspicion or not before we move forward to summary and trial.
Well, they have to. It was a warrantless arrest. They have to rule on reasonable suspicion and probable cause. Because without that, the arrest was illegal, and everything that came after it was illegal.
Right. And then,
so your argument there...
That's where the attorney's trying to backtrack.
Yeah, the argument there is... Again, it's abuse of discretion. If there is a Supreme Court case that says they cannot do what they did, and this lower court judge is saying, I'm going to allow it, then you can appeal that as an abuse of discretion. Failure to apply the Hobbs case or whatever case to the facts in the manner that the Supreme Court said it must be applied. Right. Why your attorney wouldn't know or do that, I don't know. But I would sure as shit ask them.
What normally occurs at a pretrial hearing? Because
exactly that. Pretrial issues, whether it's motions, hearings, evidentiary requirements, admissibility requirements, anything you need to argue about that's a pretrial issue. So because it can't be argued about or shouldn't be argued about at trial.
Okay, so discovery would be part of that as well if we're not
correct.
Okay. Got it.
Anything that involves the process prior to the actual trial on the merits.
Got it. Thank you.
Anything else, anybody? All right. Well, in that case, I want to wish y'all a great weekend, and thanks again for those of y'all that got your dues in for the next class. I appreciate that very, very much.